All rise. Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Evander, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments for the 5th DCA. Let me go ahead and introduce the rest of the panel for you. Seated to my right is Judge Jay Cohen, and to my left is Judge David Silverman, who is a judge in Brevard County, who has agreed to join us today and help us with our work, and we appreciate that. We have only 2 cases scheduled for oral argument today. They're both civil cases, so each side will have 20 minutes aside. The second case has a cross appeal, so if the appellee wishes, I can set aside a little time for rebuttal if they wish, but that would be limited to the cross appeal issue only. If you have any cell phones or any other electronic devices, please make sure they're turned off so that we don't interfere with the arguments at all. And if counsel, when they get up here, if they want to let me know how much time they want for rebuttal, we'll try to help you in that regard. So the first case we'll take up will be Tampa Chiropractic Center versus State Farm.
Good morning, Your Honor. May it please the court. I'd like to reserve 5 minutes for rebuttal time.
Okay.
My name is Chad Barr, and I represent Tampa Chiropractic Center, Inc. We are here today asking the court to reverse a final judgment entered by the trial court in 9th Circuit in Orlando, Florida. I'd like to start out by giving the court a brief background on this case.
We're familiar with the facts of the case. You're probably just as well going into the argument that you'd like to make. Understood.
Thank you, Your Honor. Basically, this case surrounds, in part, a conflict as it relates to 627-736-6B, commonly referred to requests made pursuant to that statute as a 6B request. State Farm in this case requested various sensitive corporate and financial documentation pursuant to 6B, and Tampa Chiropractic responded and sent an invoice for cost. The first issue on appeal is whether the trial court erred in finding as a matter of law that the time represented in the invoices submitted by Tampa Chiropractic were attorney's fees, and that those attorney's fees were not compensable under 627-736-6B. It's important for the court to remember that there is a cost provision under 6B. When a request is made and a response is provided, the statute does provide.
Your position is that attorney's fees fall within the purview of the costs.
That's actually not our contention.
And is your position that they weren't attorney's fees?
Our position is that it wasn't established as a matter of law that all the time sought in the invoices was attorney's fees. So the first part of the argument is that there was nothing to support the claim that these were attorney's fees. State Farm is the one that filed the lawsuit. They claimed they were attorney's fees. We denied and said that it was time expended on by the medical provider in responding to the 6B request.
From the law firm, correct?
The response was sent by the law firm, yes.
And it was billable hours at $300 an hour for, I'm not sure that I got the hourly rates right, but like $300 an hour for one person that worked on it, and then a lesser rate for the second person that worked on it. And your position, and you're arguing to us with a straight face that that was the time for the doctor's staff to provide these records?
My argument is that it was State Farm's burden on summary judgment to establish that those were.
You're telling us, as an officer of this court, that that was time spent by the doctor's staff?
I'm not prepared to answer that question because it wasn't a question that was even considered by the trial court. The trial court didn't consider what time that was. The trial court took State Farm's word that it was attorney's fees and that it was only attorney's fees and not any part and parcel of the doctor's time, and they simply took it as gospel that it was attorney's fees, and in doing that said that it wasn't compensable as an item of cost.
Well, let me ask you this. If it was deemed to be attorney's fees, not court costs, would you be entitled to recover it under the language of that statute?
I actually think that we would, and that was the second part of the argument that we made in our briefs and before the trial.
Not get into the confession of judgment issue, but just based on the language of the statute itself, where it says that you can recover costs, would attorney's fees be part of the costs if we concluded they were in fact attorney's fees and not costs?
If the court concludes that they were attorney's fees, I still believe that they would be compensable under 6B, primarily because of the way that it's phrased in there, that it's an item of reasonable cost.
That goes against all case law in this area. What case law do you have to support that assertion?
I think what's important to remember.
What case law do you have to support that assertion? Give me the best case you got.
There's no case that has analyzed attorney's fees in the context of 6B.
You would agree that there's a whole slew of cases that say attorney's fees are not costs for purposes of recovery.
I think that's in the context of litigation, and I think that's not what we're dealing with in this case, because 6B deals with pre-suit discovery. So we're dealing with a situation where a medical provider, and it says...
Why would there be a difference?
And I think that's an important question, because it says reasonable cost, and I think you have to look at what is actually being requested by the insurer.
Second argument, because this argument is not persuasive.
Understood, Your Honor. The second issue is whether the trial court erred in finding that it didn't have jurisdiction over the claim anymore because State Farm confessed judgment in this case. As this court is aware, it's had plenty of opportunities to consider the issue of confession of judgment. There's three primary elements. The insured is forced to file suit, there's a bona fide dispute, and the insured has a change of heart which renders the action moot. It's exactly what we have in this case. Tampa Chiropractic filed its counterclaim in this case, asking the court to declare that the 6B request that State Farm made was inappropriate and that State Farm couldn't pend payment based on the 6B request. It's important to remember that under 6B, if a request is made...
There was some issue as to whether the settlement occurred before the lawsuit. What is the record evidence on that?
The record evidence is, if we look at the pleadings, State Farm not only agreed that there was a dispute, a case in controversy between the parties, they also asked the court to declare that Tampa Chiropractic has to produce the records. Under 6B, bills are pended. The time for an insurance company to pay the bills is actually told for 10 days after a complete response to the request is made. There's no reason why State Farm would still be, or why they would have standing, or why Mr. Hazuri would be...
Repeat the question, or do you remember the question?
I remember the question, and I think that the record evidence is found by examination of the pleadings, which is a part of the summary judgment.
First hearing on it, even Tampa Chiropractic had questions about it, did they not?
The question was, is it a confession of judgment, or is it a payment that renders the action moot? And I think that's what the court failed to consider. The court made no consideration of that.
Right. I think do we know from the record whether the payment was made before or after the lawsuit was filed?
I think the record supports that the payments were made after the lawsuit was filed, and that's primarily what I was speaking to when it relates to their answer.
Well, would you agree, though, that at the hearing below, the trial counsel advised the judge that was uncertain whether it was paid beforehand?
Because the question was being made to the court, was payment made, is this a confession of judgment, or was it something that this action was moot? And the point is that it can't be that the action was moot, because State Farm asked that the court...
I understand the mootness argument, but I'm trying to get the facts right, and it just appeared from the record that your counsel below said that you weren't sure whether or not the payment had been made before or after the lawsuit was filed, and there's nothing, and the question Judge Cohen had, is there anything in the record that we could affirmatively state, as far as evidence, an affidavit, deposition, and a stipulated admission, anything in the record for summary judgment hearing purposes that the payment was made after the lawsuit was filed?
I think if the court looks at, which the court is allowed to, the pleadings, as well as the affidavit of Mr. Talley that was filed by State Farm, you can see that when this counterclaim was filed, they were agreeing that there was a case in controversy. There wouldn't be a case in controversy if they'd made the payment.
You're missing the question is, when was the money paid? Before or after the lawsuit was filed? What summary judgment evidence is there? The pleadings is not summary judgment evidence unless there's an admission, unless the answer admits a fact. The pleadings are not summary judgment evidence.
And that's exactly what they did.
They admit there was a dispute, but they don't admit when the payment was.
They don't admit that when the payment was made, but they admit there's a dispute, and they admit that, and they request that the court require them to produce the documents, which they wouldn't have standing to do unless there hadn't been a payment made, because that tolls the payment. So we're looking at a situation where we litigate this case, and then all of a sudden they show up and they say, hey, we made payments, we don't want the documents anymore. And actually, during the arguments at summary judgment, Mr. Hazuri, who is here today also representing State Farm below, said that, his exact words is that State Farm is not withholding payment anymore. And that's based on the affidavit of Mr. Talley that he filed. So
If we reject State Farm's jurisdiction argument, then either we reverse or we remand. Would that be a fair assessment?
correct.
And it just seems that at this point in time, I'm going to ask Mr. Hazuri the same question, whether there really is any dispute as to when payment was made at this point in time. Because, I mean, we're not trying to play games with it. If the payment was made after lawsuit, if we reject the jurisdictional argument, then so be it.
And I appreciate that, Your Honor. In closing, these aren't complex arguments, and I appreciate the court's questions, but in closing, just ask the court to remember that, especially under the court's ruling in Jerkins and Lorenzo case, this is a classic confession of judgment case, and I think that the pleadings and the affidavit support that State Farm confessed judgment in this case. They changed heart. They can't be allowed to withhold payment based on that. So with those arguments being said, I'll reserve my remaining time for rebuttal. We ask the court to reverse the trial court. Thank you.
Thank you. Thank you.
Mr. Hazuri, we're significantly down the line from a time frame. Assuming that we reject State Farm's argument as to jurisdiction, is there really an issue as to whether this money was paid before or after a lawsuit?
Your Honor, there's no record evidence, as Mr. Bart, and I'm going to answer your question. I am. I can tell you when the payments were made if you want to know that. There's no record evidence that.
Were the payments made after the lawsuit was filed?
5 out of 8 of them were made before the lawsuit was filed. 3 were made after the lawsuit was filed on one particular claim pursuant to settlement of another PIP case, not because of any issue in this lawsuit, is the answer to the question. But there's no evidence of that. At the summary judgment hearing, confession of judgment was raised for the first time, so those facts weren't known, but those are the straightforward answers to your questions.
I appreciate that.
Mr. Hazuri, were they paid after the amended counterclaim filed by?
3 of the claims, yes, sir. The Joseph claims, well, I shouldn't say that because we redacted the names, but there was a father and 2 minors, so it was 1 claim. And can I give you a quick timeline since the facts seem important to you? What happened here was State Farm served its 6B requests from March until September 2010. On October 2nd, 2010, State Farm paid 1 of the claims. That's before Mr. Barr even responded to the 6B request. 5 days later, State Farm paid 5 other claims, once again, before Mr. Barr ever even responded to the 6B request. So State Farm had made the decision, as I said, I believe I said in summary judgment, that the decision was made, we're not going to pour resources into this clinic, we're directing our attention somewhere else, we're not going to pursue these records, etc. Then the responses came in asking for attorney's fees, which is why we filed the deck action we did. The other 3 claims involving the adult and the minors, there were PIP suits filed on the 2 minors. State Farm was trying to get an EUO to verify the claim and what have you, and ultimately State Farm got the EUO of the father and decided to settle the PIP suit. That was settled, PIP benefits were paid after the counterclaim was filed.
So the bottom line is that if we reject State Farm's argument in terms of jurisdiction, that it would require a remand.
I don't think so, Your Honor, and I can tell you why.
Okay, tell me why.
Because this is not a confession of judgment, even if you accept that payment under 5th DCA law. And the issue is, did State Farm roll over on this lawsuit, the issues in this lawsuit, the scope of the 6B, et cetera, and do the facts bear bear out that they rolled over and paid as a result of this lawsuit, and the facts as I've just told them to you do not bear that out at all. State Farm abandoned its position and stopped seeking these records because it wanted to direct resources elsewhere before the lawsuit was even filed. I would point the court to its decision in Lorenzo, 969 Southern 2nd, 393, and say, while Florida law does hold that payments are treated as confessions of judgment where an insurer first disputes the claim and then settles, the existence of a bona fide dispute and not the mere possibility of a dispute is a crucial condition preceding to such a holding. Here, as noted above, there has been no such breach shown. There wasn't a bona fide dispute over the scope of the 6B request at the time they filed their counterclaim. State Farm had paid 6 or 5 of the 8 claims before the lawsuit was even filed, frankly, before Mr. Barr even responded. And the other 3 were not paid, had nothing to do with the 6B request.
At this point, that's known to us because we have asked you.
Right, correct, and I told you.
That puts you in somewhat of an awkward position, but in terms of deciding the case, we really would have to go based upon the record evidence.
Yeah, that's a better answer, frankly, and that's where I was going next. This is the problem with Mr. Barr not filing any evidence on the payments in the trial court. When you say record evidence, I'm taking your meaning what was filed in the trial court properly in opposition to State Farm's motion for summary judgment, which was nothing. And this is the problem when you don't file anything like he did. We don't have a chance to respond. I don't have a chance to research and make the type of argument that I just made to you in the trial court, and we don't have a ruling on that. So that is why it's so important to have record evidence in opposition to the motion for summary judgment from them.
Side of that is, as the movement for the summary judgment, you were required to show the lack of any disputed material issue of fact, and y'all didn't put anything on there that all payments were made before the counterclaim. I mean, so the record doesn't show when the payments were.
I agree with the second.
You all are the ones that got the summary judgment, not them.
Yeah, well, I don't think the burden is correct, as you just phrased it, Your Honor, respectfully, because here, and I've thought about this, believe me, because it's an interesting issue. We're the plaintiff. Oh, I'm sorry, this is the counterclaim. We're the defendant on the counterclaim, okay? So they bring their counterclaim, and we ultimately bring a subject matter jurisdiction challenge, because we say it's moot, and under all the cases, there's no subject matter jurisdiction, right? So that's basically an affirmative defense. You can assert subject matter jurisdiction anytime. At that point, it's their burden. What they're now arguing is confession of judgment. That's an avoidance of our affirmative defense. And I argued in the trial court, they never pled this. They never argued it. They came in and they just put it on the table at summary judgment. So they didn't perfect the right to make the argument by filing a reply setting forth the avoidance of the affirmative defense, which again, coupled with evidence, which they didn't put on, would have framed the issue properly before the trial court. So I don't think it was our burden, because it was their burden to properly raise it as an avoidance to our subject matter defense argument. And that's the whole thing. They came in at summary judgment with no evidence and just kind of sprung this on the trial court. And I want to add, I didn't address specifically a lot of the issues we're talking about now in my brief, because their argument on appeal was State Farm confessed judgment. They said over and over again, State Farm paid after the claims were filed in the absence of any record evidence on that. And so that was different from what they argued in the trial court, which Judge Cohen pointed out, or maybe it was Judge Vander, whichever, I apologize, that it was, Mr. Barr was very clear in the trial court that we don't know when the payments were made. And therefore, he argued the type of argument that you just put forth, Judge Vander, that there were issues of fact, and then they came up on appeal and they changed their position in a subtle but very important way and said there was a confession of judgment. State Farm paid after the lawsuit was filed, and there was zero record evidence of that. So I narrowly tailored the argument to that position, and I put in there that if they try and raise in the reply brief that there were issues of fact, that they have waived that argument under this court's case law. In fact, it's a violation of due process to take it up. They should have just, stuck with their arguments.
Underlying argument, do you believe that your request to produce below, or your request for documents, was something they had to respond to under the statute, or do you think that your request was well beyond the scope of the statute?
We think it was within the scope of the statute, but that was not litigated for all the reasons we're standing here right now, or you're sitting here and I'm standing here.
That's as persuasive an argument as his attorney's fees argument was.
That we were within the 6B statute? Well, I guess you've given us some guidance for another day then on how you feel about this, Judge Cohen. I guess, again, I would point out, to me, that's a real important issue on appeal, that they argue that State Farm paid, and there was no record evidence of that, not that there was an issue of fact. So I think they've waived that argument and the type of argument that you put forth, Judge Vanner. But at any rate, it was their burden to raise it via reply, because it's an avoidance of an affirmative defense, and they did not do that. So you can't just show up at a summary judgment hearing, say confession of judgment, no evidence, and defeat a summary judgment, when that is an avoidance of an affirmative defense. The reason we have these rules of evidence and rules of summary judgment that require affidavits and competent evidence is so that we don't come in here and have discussions of things that happen off the record and all the dynamics. I mean, if that's how cases are going to get decided, then we have chaos, essentially. I was quite certain you guys would ask me when the payment was made, and I wanted to answer your question straightforward and give you the information.
Well, as Judge Cohen mentioned, we're not going to go beyond the record to rule, but if there's going to be a stipulation, certainly if the parties stipulated as to a fact and oral argument, we could accept that. But if there's not going to be a stipulation, any decision we make is going to be based on what's in the record.
I'm telling you straightforward what happened. I'm not saying we're stipulating or waiving evidence in the trial court. So I guess a related issue that I'd like to touch on here, which is frankly what this case comes down to at this point, is attorney's fees. They're arguing, they've made this, they filed a counterclaim saying we want a declaration on the scope of 6B, because it's very important that doctors don't get harassed, and that, this is important for the community. And then the first chance they get, they jump and they say, you confess judgment. So now we don't want an answer about those issues. We just want a ruling that you confess judgment. The reason they want a ruling on that is because they want to get paid their attorney's fees. When they served their demand asking for attorney's fees, that's what initiated this whole dispute. They're seeking of a...
But you're telling us that PIP cases are about attorney's fees. That's a shocking...
I know it is, Your Honor. I know it is. I'd point out this is not... It involves the PIP statute. It's not technically your classic PIP case where they're recovering PIP benefits, which is a nice segue into what I was going to tell you. If you remand this case, if you accept their argument on the second issue, I'm only talking about the declaratory judgment moot issue because I think it seems like you know where you're going on the first one. But if you remand this case, okay, they have not recovered PIP benefits in this case, and in fact, they haven't recovered anything. Now, we did pay PIP benefits on another claim. The two minor claims and the father that I told you about, that was done pursuant to a separate PIP suit that was settled. Their counterclaim in this case does not request the payment of PIP benefits. It does not have an action for damages. It does not demand the payment of PIP benefits. So were you to reverse and remand on the second issue, the issue becomes, well, what about attorney's fees? Because there's a motion for appellate attorney's fees, and they'll be seeking their fees if they got a confession in the trial court. So this becomes important, and this is briefed. The motion for fees and the response is briefed. This falls squarely under Progressive Rural Metro, the court's more recent decision of Mazaghi, and what have you. Basically, what they've done is they've litigated an issue that is part of a claim for PIP benefits, related to a claim for PIP benefits, but they don't seek recovery of PIP benefits. In other words, if they had won on this case, that would not be an adjudication that they're entitled to PIP benefits, because we could still be defending on reasonable, related, or necessary. We could still be defending on any grounds and just decided we didn't need the documents that we requested in the 6B request. So...
Well, but all of that is in relationship to a claim for PIP benefits.
It relates to?
Yeah, I mean, that's the context that all of that arises. It's not, freestanding.
Yeah, I will certainly agree with that statement, Your Honor, but that's not enough, especially if you look under the Shaw case, the opinion was, the fee order is not, it's not an opinion, but I worked on the case and I know what happened. In Shaw, the court ruled that the case was about, does a medical provider have to sit for an EUO, after it takes an assignment of benefits? And this court ruled that the medical provider was correct, that it does not have to sit for an EUO. Okay? So in other words, State Farm cannot withhold payment to the medical provider while, until the provider sits for an EUO. Directly analogous to this same type of case, can State Farm withhold payment to the medical provider while waiting a proper 6B request, at least in state 6B response? And if that question, if you were to either remand this case or to answer that question in the provider's favor, or if the trial court was to, it's the exact same posture as Shaw. Okay, they've gotten a ruling that part of something that relates to a PIP claim is in their favor. They don't have to sit for an EUO in Shaw. The 6B requests, either we confess judgment or they were improper in this case, but it is not a ruling that they're entitled to PIP benefits. The same way in Shaw, it did not result in the payment of PIP benefits. It's basically taking a collateral issue out of a PIP claim, bringing a separate action on it, and then saying, all I have to do is win on this one thing and I get paid attorney's fees, whereas what has to happen under Shaw and under Rural Metro and Progressive is you have to prove your entitlement to PIP benefits. That means defeat all potential defenses there too and get a ruling that you're entitled to PIP benefits.
Mr. Hazuri,
Yes.
by definition, a declaratory judgment action does not advance a request for damages. Is it State Farm's position that where the plaintiff has only advanced a declaratory judgment action, that there can be no confession of judgment? No,
That's not State Farm's position. The classic example of a declaratory action in the insurance context and where you can recover under 627-428 is in the third-party situation if you sue to establish coverage. I don't know if there's a 50 DCA case on that, but the case law across Florida is pretty solid on that. So if you cause an auto accident, you're accused of causing an auto accident, State Farm's your insurer, State Farm denies you coverage, you can file a DEC action to say, give me third-party coverage in this case. And if you prevail on that case, you have procured coverage. You have gotten coverage for yourself, which is all you're entitled to on that claim. Defend and indemnify me, give me coverage. In that type of DEC action, you have secured the only benefit that you can seek in a DEC action for yourself, and you get fees under 627-428. In this case, a first-party PIP claim, just to cherry pick out one issue that might be relevant to whether you are entitled to get paid PIP benefits, which is what this is. Let's cherry pick out the 6B issue and litigate that separate from whether we're entitled to PIP benefits. If you win on that case, you have not gotten the PIP benefits. You have not recovered anything. And so in that type of DEC action, a first-party DEC action involving, at the end of the day, the payment of insurance benefits, PIP benefits, it's not enough just to do a DEC action on one collateral issue that's relevant to that determination. That's the distinction here. And think about it, there's the Massagee case, if you read that, and it's the underlying orders in our motion, and it was affirmed. There's a very good reason for this, because if you start letting attorneys and providers cherry pick out, okay, I'm going to file a lawsuit over the 6B issue. Now I'm going to file a lawsuit over the EUO issue, all on the same claim, and I'm going to file a lawsuit over whether there needs to be pre-suit disclosure of the insurance policy as Progressive Rural Metro was about. That's what was going on in this field. Attorneys representing medical providers were cherry-picking issues and filing DEC actions on them and just saying, if we just prevail on this one issue, you pay us fees. That's what I encourage you to read the Progressive Rural Metro case. That's what that case was all about.
They get the benefits, and the benefits were initially disputed, but they ultimately get the benefits. Are they entitled to those fees if it's part of the reasonable progression of the case to prevail on these various issues?
I think that's a fact-specific inquiry. I think possibly. If I guess the way I would say it, it's a fact-specific inquiry. If the facts, the evidence in the record bore out that the payment was made to settle the lawsuit, PIP benefits were paid. In other words, the insurance company says, I don't want to fight this lawsuit. I'm going to go ahead and pay benefits pursuant to this lawsuit, and the facts bear that out, then that's your confession of judgment. Under words, I would submit to you, Your Honor, and again, there's no evidence in the record on this, that's a different situation where you've got a DEC action like this case where they're not requesting the payment of benefits, okay? State Farm declines to pursue the records that are at issue at the case before the lawsuit is filed, in 5 of the cases before Mr. Barr responds, and then in a separate PIP suit that's been filed, a PIP suit filed to recover benefits, State Farm decides it doesn't want to defend that PIP suit, it's on the same claim that's in the deck action, I would submit to you that the settlement and the attorney's fees are paid in the PIP suit, which is what State Farm did for the two minors. And this is a collateral issue. State Farm did not make the payment over here because it declined to defend its position in the deck action. So these are the fact-specific matters I think you would have to get into, and that's why I read the quote from Lorenzo, the key language of which is, while Florida law does hold that payments are treated as confessions of judgment, where an insurer first disputes the claim and then settles, we dispute your right to PIP benefits, you've sued us, we're going to settle and pay your PIP benefits and your reasonable attorney's fees. That's different from you, by the way, they sued us, you, medical provider, sued us over here on a specific issue, the scope of the 6B request. We don't want to fight that fight, we're not defending that fight, we're not seeking the record, so your predicate for a bona fide justiciable controversy is not there. And you also filed a PIP suit against us over here, we're going to go ahead and pay your PIP benefits on the PIP suit over here. To me, that's not, if you call it meeting of minds, it's not the objective theory of contracts. The two parties did not come together in this deck action and say, we settle, we give up, we're going to pay your PIP benefits, and there's liability.
Issue, I mean, if they have to, if State Farm sends a letter out and says, we're not going to pay these benefits unless you give us, and then the laundry list of what they wanted in this case, and that forces them to take some action. And then, so they do, they take the action, they file the deck action, and then you pay the claim. That just seems to flow in the natural course of litigation.
It could, and that's why I said it's a fact-specific inquiry. You just put forth some facts, and I think if everything unfolded pretty much the way you said, then I think you're right. That's not what happened in this case. Again, let me just be clear, this is not in the record, but State Farm paid 5 of the claims before they even responded.
Mr. Hazuri, your time is up, but if you want to wrap up with 20 seconds or so.
Well, thank you. Again, the point on that issue is State Farm paid 5 of the claims before they even responded, which shows they weren't looking at this clinic for de facto ownership, which is what the investigation was about. They decided to devote resources elsewhere. The only 3 that were paid after the suit was filed were paid for totally different reasons, wholly unrelated to the 6B situation, which State Farm stopped pursuing before suit was filed. So I don't think even under those facts, which are nowhere found in the record, that you have a confession of judgment here. And I don't think you're entitled to attorney's fees because they didn't recover PIP benefits. Thank you.
Thank you.
Just briefly, Your Honor, I keep my comments succinct. Much of what Mr. Hazuri argued was not in his brief, and I can't respond off the cuff to his arguments about whether the confession of judgment or whether the deck action results in attorney's fees at this point. It wasn't discussed in the briefs. But what I thought was important was he was asking you to consider this case in light of why they made the decision to do what they did. And I've read through O'Malley. I've read through it in great detail. I've read through Jerkins. I've read through Lorenzo. None of those cases consider why the insurance company did what they did. It only considers that they did something and that they changed heart. Lorenzo, the analysis is applicable to this case, but the holding is not, because in Lorenzo, this court is well aware, the insured was actually concealing the basis for the payment. They were concealing whether they had engaged a contractor. It's not what we have in this case. Tampa Chiropractic wasn't concealing anything. They received these letters. They were told they weren't going to be paid until their responses were adequate. They didn't receive payment, and they filed a counterclaim. They were hauled into court first and filed a counterclaim. So that's what we're dealing with in this case. I don't think the case law is concerned one bit why State Farm did what they did, if they decided to direct resources elsewhere. Well, there's no record evidence of that. And quite honestly, it doesn't matter. Under those 3 cases, the Seminole cases in Florida, it doesn't matter why they made the payment. The fact is, they did make the payment. They confessed judgment. They agreed there was a dispute. They forced us into litigation, and then they settled the suit. And that's what we have in this case.
Well, we don't know the timing of all that. That's what we're struggling with.
And I think what's important with that is, if the court doesn't accept the argument that this is a confession of judgment, I think that it should remand for the lower court to make a determination on whether it was or not. Because this can only be one of 2 things. It can only be a moot deck action that shouldn't have been filed in the first place because all the payments were made pre-suit, or it's a confession of judgment. And I think that's what the court, my argument is that it is a confession of judgment, but if not, if the court doesn't accept that argument on remand, the lower court should be instructed to determine whether it was or not. And that's the important thing that should come from my closing remarks here, is that the trial court didn't make the proper inquiries and disregarded arguments that I thought were supported by law and the facts in the case. And the last thing I just want to touch on, Mr. Hazuri, I didn't understand his argument about the switching of the burdens. He said that I should have filed a reply to an affirmative defense. He had no affirmative defenses. There were no affirmative defenses to the counterclaim filed by Tampa Chiropractic, and I don't buy into the argument that because he filed a summary judgment, I have an affirmative duty to file a reply to that. If they didn't meet their burden, there's no duty for me to supply a response, so no response was filed in this case.
Yeah, do you think confession of judgment is an avoidance that needs to be pled?
I don't think it is, because you don't know you're going to get a confession of judgment until it happens. So how can you anticipate a confession of judgment? And I just don't conceivably see how you would do that. Every deck action, every lawsuit would include a reply that says, hey, by the way, there might be a confession of judgment, and we all have to have a good faith basis for what we file. So I don't believe that it has to be filed that way. I think that if the argument was the court doesn't have jurisdiction over this claim anymore, the court has to say, in this instance, because it was a result of a payment made by State Farm, was this payment made before or after? And if it was made after, it was a confession of judgment. And it's our position that the record supports that this was done after. They agreed there was a controversy. They asked for the documents.
What if some were done before and some were done after?
I don't think it changes the posture of the case, because everything traveled the same. There wasn't, we're litigating this one issue over here, this case over here, this case over here. Everything happened together. The case traveled together. And there was no parsing out of the claims. I think that if State Farm, if they wanted to, they would probably argue before the trial court that the total amount of the attorney's fees, if they were awarded, should be reduced by the number of claims that were paid before. But I don't see that is even conceivably possible, only because this case traveled together. There was no parsing out of these claims. Everything was filed as one, everything traveled as one, everything was argued as one.
So if there are 50 claims, they pay 49, don't pay one, you get your entirety of your attorney's fees.
I think that would be I think it is fact specific. I think you have to look at what was pending and what was actually recovered. And in the situation where you have 50, 49 are paid and one's unpaid, I think you're going to have a lot of discovery, that's a lot of issues dealt with that are to claims that aren't viable. And just to get that one, I think then that would go to the the lodestar determination of attorney's fees and that sort of thing. But in this case, there was no discovery. It was just literally, we filed our pleadings, we went to summary judgment, and we went to summary judgment, and now we're on appeal. So I think the inquiry is not as intense with this case, because there was nothing really parsed out with these claims. They all traveled together. So I think that at the end of the day, the elements...
That would be a determination for the lower court to make.
I would agree, yes, Your Honor. So at the end of the day, yes, Your Honor.
Let me ask, does the payment of the benefits following any deck action with respect to records by an insured constitute a confession of judgment? What do you say to Mr. Hazuri's argument that even such a payment would not constitute a confession of judgment because it was a collateral issue on the deck action? I
think the point is that we weren't dealing with a situation where they just said, we don't want the documents anymore. We'll litigate the rest of the PIP claim. They said, we don't want the documents and we're going to pay. So we're sitting in a situation where, similar to O'Malley, where the insured has been sued by the insurance company for a deck action to determine coverage, and the insurance company says, we're going to give you coverage, and we settled the claim. So they're getting the end result out of that deck action, and that's what we got in this case. We got the end result, which was payment of the claim. So we're not dealing with a situation where we just got them to say, we don't want the documents anymore. They said, we don't want the documents anymore, and we paid the claim. So it's a bit of a different situation.
Would your position be the same if you had never filed a counterclaim? In other words, if they just filed the deck action and then went ahead and paid the claim, would you still be in a position for claiming a confession of judgment?
I don't know, because we would only be dealing with the issue of the cost, because their original lawsuit was just filed as to the cost. It wasn't as to coverage or PIP benefits or anything like that. So Unless the court has any other questions, I'll forfeit the remainder of my time, but we would ask the court to reverse and remand this case. Thank you very much.
All right, thank you. Thank you both.
Thank you.